Schumer yesterday unveiled the parameters for a Senate trial, what he would like to see. He wants Mick Mulvaney, the acting chief of staff, and John Bolton, the former national security advisor, to testify. Should they have to testify?
Well, the first question is, are there sufficient allegations to justify a trial? Remember, the analogy is a grand jury. The House is the grand jury, the Senate is the jury. And if the grand jury has indicted for something that's not a crime, for example, if a grand jury indicts a man and a woman for marrying each other and they're of different races, obviously that would be unconstitutional. You wouldn't have a trial. You'd make a motion to dismiss. And here we have two allegations that are not in the Constitution, that are the kinds of allegations that the framers of the Constitution were very much against. So I think the first issue is whether there should be a trial at all, or whether the allegations fail on their face. And I think that decision has to be made before you introduce any evidence. The hypothetical I've given, if you had a married couple, there would take no evidence on that. It would be unconstitutional to have a trial. So I think the first step has to be to determine whether the impeachment allegations satisfy the criteria. Take, for example, obstruction of Congress. The obstruction of Congress is because the president, as head of the executive branch, demanded that before any people in the executive branch comply with a subpoena, there'd be a court order, there'd be a judicial order. Just Friday, the Supreme Court granted certiorari review in 3 cases in which they said, we're going to look at that issue. So obviously, that is a very plausible issue, and that can't be a ground for impeachment. So I would strongly recommend that Democrats who are now on the fence, or who live in districts where they know their constituents are not strongly in favor of impeachment, should at the very least strike the obstruction of justice from the charges. There's just no basis for that, and the Supreme Court, I think, pulled the rug out from under the Democrats in the decision on Friday to grant review of cases involving the power to subpoena and whether the president has the right to invoke various privileges.
On the abuse of power, do you believe that the president asked a foreign government to interfere in our elections?
I'm not involved in the facts of the case. I think the evidence has to be looked at, but I don't think that would be a grounds for impeachment. I think presidents constantly take actions that are designed to help their electoral prospects. If you go back to abuse of power, and if you allow that to be a criteria for impeachment, Abraham Lincoln suspended the writ of habeas corpus. Franklin Roosevelt confined 110,000 Japanese Americans in detention centers. John Kennedy authorized the tapping of Martin Luther King's telephones. We've had every controversial president has been accused of abuse of power. And so I don't even get to the factual issues. Abuse of power is simply not a criteria. If the framers wanted abuse of power to be a criteria for removing the president, it would have been simple. Just put it in the Constitution. Treason, bribery, other high crimes and misdemeanors, or abuse of power. They didn't do that. They didn't do obstruction of Congress. And this is, as Jonathan Turley, I thought, aptly put it, this is not a jazz concert where improvisation by Congress is to be accepted. There has to be a violation of the specific terms of the impeachment provisions in the Constitution, and that's just not been alleged. And if it hasn't been alleged, what the facts are is not significant. You have to first decide whether there's been an allegation of an impeachable offense, and I think the answer is there has not been an allegation of an impeachable offense. I'm surprised that Democrats didn't put bribery in there. Well, they were talking about it, but they left bribery out. That would have at least satisfied the words of the Constitution. Then they would have had to prove the elements of bribery, which I think they couldn't do, which is probably why they left it out. But to go to 2 vague criteria like obstruction of Congress and abuse of power is Hamilton and Madison's nightmare.
In the 600-page report that was released by House Judiciary Committee Democrats last night, they do say bribery. They point to bribery and saying the president solicited a bribe by asking the Ukraine leader to call for an investigation into the Bidens in exchange for a White House meeting and that military aid.
So why don't they put that as one of the allegations that is to be voted on by the Judiciary Committee and then voted on by the House? You can't just throw things in there and accuse people of things. If you're going to make an accusation, put it as one of the charges, and then that can be debated, but you can't have it both ways. You can't charge abuse of power and obstruction of Congress as the only two impeachable offenses and then say, and by the way, there's bribery and there's other things as well. You have to really decide what you're going to charge the president with. That's the minimum required by due process of law.
So, Mr. Dershowitz, you don't think then abuse of power, that the Democrats' allegation that he solicited a bribe is an abuse of power?
No, the point I'm making is a very different one. That is, abuse of power is not in and of itself a criteria for impeachment. Even if they were able to prove abuse of power, that may be a good reason for voting against somebody in an election. But abuse of power is just too broad a concept. I can give you 20 presidents throughout history that have been accused of abuse of power by the opposing party. Most recently, obviously, when President Bush went to war in Iraq, he was accused by Democrats of abuse of power. President Obama was accused of abuse of power for the Fast and Furious. It's a cliche that gets thrown around politically. It's the last thing you want to be a specific criteria for impeachment. Abuse. What does abuse mean? And it's just too vague and open-ended. It's exactly what Madison said. Madison said you do not want open-ended, vague criteria that can be used against any president by the opposing party. And in Hamilton's terms, that would turn impeachment into who has the most votes, which is exactly what we're seeing. This is the first impeachment in history ever to go strictly along party lines. And that's, again, what the framers were very strongly opposed to. That's why they required a 2/3 vote in the Senate, presiding the Chief Justice. I wish they had also required a 2/3 vote in the House, but they didn't. They analogized it to a grand jury, 23 members of the grand jury. All you need is 12 to indict, but then you need a unanimous jury to convict.